This is lecture 5, continuing on with the North Carolina cases. And in this video presentation, we're going to be reviewing State v. Black and State v. Rhodes, the next two cases in the line of 6 cases. State v. Black is the first case in the line where a husband is prosecuted for assault and battery against a wife. And we're going to see the ideas and concepts from the teacher-student context in Pendergrass, and then the rhetorical response to the wife's petition for divorce in Joyner. We're going to see all those ideas migrate very quickly into this context, this new context of criminal prosecution against the husband. So I'm going to share my screen for a bit, and we're going to go through these two cases and try to figure out what's going on. PowerPoint. Okay, so State v. Black. So right off the bat, and I can actually pull up the document. So it's so short, why don't we just read it? So you can see this slide. Right off the bat, we're given this two-pronged test, this two-part statement of the limit on the husband's authority. The court doesn't tie this to Pendergrass. It doesn't tie it to Joyner. There isn't any defense of the migration of the ideas from parent to child, teacher to student, husband to wife. As in Joyner, where there was a strong rhetorical emphasis on what if she's provoking him, you're going to see some actual discussion of provocation here as a factual matter that influences the analysis. But it's so short, it's one page, and it's the foundation. So we can actually read it if you can actually read the poor quality of the copy here. But right out of the gate, it's husband is responsible for the acts of his wife, and he is required to govern his household. And for that purpose, the law permits him to use towards his wife such a degree of force as is necessary to control her. And unless there be some permanent injury or an excess of violence or such a degree of cruelty as shows that it is inflicted to gratify his own bad passions, we're using a shorthand for all of that called malicious intent. The law will not invade the domestic forum or go behind the curtain. So let's pause there. So we have these two ideas as limits, and they're recast or glossed slightly in this slightly bigger frame. This is a very powerful idea, this use of the metaphor of a curtain. But you're really not supposed to lift up the curtain and look under it. So there's a zone of privacy. And there's a problem with the public gaze into the private realm or the domestic realm. So that's why there are these limits, or part of the reason there are these limits. One reason is the husband must and should and does have this authority, but also we don't want the public looking at these private quarrels unless there's some fairly extreme limit passed, like permanent injury or malicious intent. So that's new, this idea of the curtain. It prefers to leave the parties to themselves. Now, we're going to see in Rhodes that this idea of judicial intervention doing more harm than good becomes even more prominent, right? But that's there. And the court goes on to say that, you know, if you expose this, if you get people involved in litigation, if there's a criminal prosecution and witnesses, people dig in their heels, they polarize, they're much less likely to forgive and forget. Of course, with modern eyes, we can ask, well, from whose perspective, you know, does it do more harm than good? Certainly it does, it's good for the husband to have this approach to leaving the parties to forgive and forget. It may not be so good for the wife. And then we get the facts, or at least a little sketch of what we can discern. We're told that the wife commenced the quarrel. We're told that they're living apart. They're not living together, but they're still legal, their legal status is married. So would that affect the case? We're told that she verbally abused him, and we get this image of him dragging her to the ground by her hair. There's an intimation that he sort of checks himself. He doesn't strike her. We're told he doesn't choke her. And this is what happened. And after he let her up, she continued to verbally abuse him. So here's this idea of provocation. She really did come at him with verbal abuse in the context. And, you know, there is a fuller statement. This is an edited version. So if you read the full case, you get a little more detail that she was accusing him of sleeping with someone else and, came out and accosted him on the street. So there are lots of witnesses around. Um, and there is this concept of what is called a directed verdict. So um, it's implied that the husband loses the case um, at trial. Um, but what the appellate court is saying is that the trial judge made a mistake. And this is the directed verdict idea, that in favor of the defendant, the court can say, all right, these are the facts. No rational person could dispute that these are the facts. The facts are not in dispute. We know what the facts are. Okay, so what's the law? And what the appellate court is saying, and it's really their role to articulate and manage and disseminate the law, the norms. The appellate court is saying, um, under the law, he clearly did not exceed his legal authority, because on these facts, no one could conclude there was malicious intent. So he should have been found not guilty without the jury even deliberating. The judge should have directed the jury to find for the defendant, because the facts were not in dispute and the law is very clear. So that's the case. And we start with this two-pronged test, right? So just to go over it, was there permanent injury? That's one limit. So no matter what's going on in the perpetrator's head, if the perpetrator causes permanent physical injury, that's over the legal limit, and the husband can be held accountable. Second, even if there's not permanent injury, was it malicious? Was there malicious intent? On these facts, the court holds clearly no, and a verdict should have been directed for the defendant. Okay, so when we get to Rhodes, things get really interesting, right? Here, we're told very little about the violence, but a couple of facts are crucial for the analysis. And this is 4 years later. So we're told that the husband hit his wife 3 blows with, this time, a weapon. So that's a difference, right? In black, it's hands. In Rhodes, there's a weapon. It's a switch or a whip-like instrument. We're told that the circumference of it is smaller than a thumb. That becomes a relevant fact. So when the court says size, it means the circumference of the switch. We're not told how long the whip was. 3 blows. And most importantly, it's assumed on appeal in this case that this beating was unprovoked, that she did nothing immediately proximate to the violence to bring on the violence or provoke the violence. And the court is assuming that, right? We could always say, oh, she said something 3 months ago that bothered me and I just got around to hitting her for it now. But no provocation. This was an unprovoked beating, and the husband is prosecuted for assault and battery. And the court also says, look, if they weren't married, he'd clearly be guilty of assault and battery, right? So they are married. So how far does that affect the case? All right, so if you're a prosecutor, you might argue that state v. black states the law. There's a 2-pronged test. If he hit her with a whip 3 times and we're assuming that it's unprovoked, how could you say that isn't malicious? So he's crossed the line and he should be prosecuted, and that's our case. Here are the facts. Here's the law. He should be found guilty because he's exceeded the legal authority that the law gives him. But that isn't what the court concludes. That is not the court's argument. The husband is going to be found not guilty. So State v. Rhodes is kind of a very important transitional case in the line. And I want to suggest to you that you see a great deal of anxiety. That is, the judges are very uncomfortable with what they're doing. They acknowledge early on that North Carolina is going to be, with this decision, pretty far out of line with most other places, most other states, most other countries that are, quote, civilized. Mississippi and North Carolina are in agreement, but if that's your only friend, maybe you should pause and think about it. So that's what they're aware that they're out of line. So there's a kind of an elaborate justification of why this husband has not, in fact, exceeded his legal authority, even though he hit her with a whip 3 times and it was unprovoked. So how do they do that? And that's your task in reading, trying to read very closely this opinion. And I think we can also observe that there's even a broader frame. So we have the two-pronged test in State v. Black. We saw it tied to this idea of the curtain, tied to the idea that's sort of doubled down on in Rhodes of intervention doing more harm than good. But here in Rhodes, there's this new idea of family government, that all families have a government, and that government is subordinate to the state, but complete in itself. This is the kind of rhetoric. It's almost like setting up the inappropriateness of piercing this veil, of getting behind this wall around the family government. Your editors rightly ask us to think about what form of government do these families have. They seem to be sort of autocracies or monarchies or whatever you would call something not terribly democratic or fair. So the court is going to make an argument that even this is okay. Their hands are tied. It's how to characterize it. I think you could say the court is saying, well, what we've been meaning to say is we only intervene, and it uses this language several times, we only intervene if the husband grossly abuses his authority, right? And we can't have, it would do more harm than good to have the courts intervening in trivial disputes for the reasons articulated in Black and maybe evident here. It's going to make it harder for people to forgive and forget. It's going to expose to the public scenes that shouldn't be exposed to the public. Judgments have to be individuated. So there's a whole lot of writing about what things are like for, poor, trashy people and middle-class people and upper crusty people, and how things have different meaning for different classes of people. But the ultimate answer is this violence doesn't rise to the level of maliciousness, even though it was acknowledged to be unprovoked. Now, there's a wrinkle here, and it's not terribly important, but it is absolutely confusing. So I'm just going to go over it really quickly. What happened at trial in this case, you don't really find out until the end of the opinion. But what seems to have happened is the trial court judge told the jury what the law was and got it completely wrong. So the trial judge is sitting there, the case is tried, and the trial judge says, there's an old rule that it's called the rule of thumb. And if you hit your wife with an instrument that is not thicker than your thumb, you're okay. And if it's thicker than your thumb, like a tree branch, then it's not okay. And this is really folklore or folk wisdom. It's not the law. It's a trial judge just totally getting the law wrong. But since the switch was smaller than a thumb in circumference, the husband won at trial, right? And it's the state that's appealing about the law. And what the court is doing in Rhodes is articulating a different view of the law. It's not, the rule of thumb has never been law, it's folklore. But what the law is about a line between grossly abusing the authority and what's trivial if we're thinking about malicious intent. And the husband wins. The husband wins at trial for the wrong reasons. He wins on appeal, the court is saying here, because a proper analysis tries to leave us out of these disputes. So let's ask some conclusion, let's ask some questions about this case and think about where it goes in the next two cases, Mabry and Oliver, right? So one thing you might think about, and this is common in law, the way concepts and categories take on meaning in light of other concepts and categories and how they move together. But we're left with a puzzle. Nobody has explicitly articulated the legal status of this idea of provocation, of a verbal aggression justifying physical aggression, right? It's only wives who would provoke husbands in this sense. It's not symmetrical, but we have this idea, but nobody's saying what its legal status is. They're just saying whether it's factually present or factually absent, right? How could it be related to malicious intent? So you might say, well, if provocation, then no malice. Absolutely, always. What if the violence in response to the provocation is wildly disproportionate? Would it then still be malice? But provocation, the presence of provocation would make it less likely that you would find that that violence would be malicious. They have to be related in this logic that's going on in these cases. If no provocation, right? I mean, if provocation, then no malice. If no provocation, then malice. I think I screwed that up, but you get the idea, right? Uh, the first proposition, if there isn't provocation, then malice, well, we know that's not true now. We didn't know before Rhodes, right? Before Rhodes, we might have thought if no provocation, then per se malice. But that's not the case. We now after Rhodes, we have to take into account perhaps weapon versus no weapon and what the weapon is, and all of the contextual facts about the nature of the violence, right? It's really hard to start formulating any kind of predictive power here, right? Well, how could you predict how the next case is going to come out after this case? You're supposed to be able to, right? So, and this is the final point I want to raise about this case, and I think it's an important one, and I'm gonna pop up the text again so you can see it. At the end of the opinion, and I said before, the opinion is rife with this anxiety, like they're just not comfortable. They're going to do it. They're going to protect the husband's ability to do this, but they're not comfortable doing it. And near the end of the opinion, the court says, we are not saying that he has a right to hit her, right? He does not have a right to hit her, but it just would do more harm than good if we intervened in something that wasn't serious. This is still on the trivial side of the trivial serious line. It's a policy decision. It's like cost benefit. We don't want to say that he has a right to do it. Two boys, they're 14 years old, they have a fist fight on the playground. Nobody would say they have a right to punch each other, but we're not going to drag that into court. The teachers and the parents are going to handle that, and that's kind of like what we're doing here, right? There are lots of institutional spaces where courts don't belong. People have discretion. It's kind of hard to control that discretion and judgment. If they have authority, if they're police officers, we can't, until body cams, we can't watch everything they do. Teachers in the classroom, we can't watch everything they do. Bureaucrats in welfare offices handing out benefits, we can't really watch what they do. There has to be a certain amount of non-intervention and trust. This is the argument. Now, your editors have something to say about this line. And, ooh, wrong document. There we go. Oh, there's the Rhodes opinion. Here's the language I'm talking about in Rhodes. It will be observed that the ground upon which we have put this decision is not that the husband has the right to whip his wife much or little, but that we will not interfere in family government in trifling cases, right? So there's no right, but we're not going to intervene in trifling cases. We wouldn't interfere if the husband whips the wife or the wife whips the husband. That's cute, right? You know, if all right, I'm not gonna make that joke. Never mind. But point two here is what I want to highlight, and I probably will ask you to respond to this in one of our next weekly exercise. Tell me what you think of it. Point two: if the court, this is your editors commenting on this line, right? If the courts will not involve themselves in family quarrels below a certain threshold of violence, and it is likely that husbands will be the aggressors in family assaults, has not the court, through a promise of inaction, and that's what it's promising, acknowledged the right of the husband to chastise up to that threshold, right? So, so think of it this way. The court could say the husband has a right, it is right, and he's doing it, and that's good. That's not what the court is saying. The court is saying, we're not saying it's right, we're just saying it would do more harm than good to intervene. Your editors seem to say, well, that's BS. That's a lie. And maybe it's even worse than saying it openly and honestly. If the court said it, we could see it and deal with it. But this is a cover up. This is ideology. This is ideological smoke in your eyes to hide the power, because in effect he has the right. He has the power, authority, with impunity to go up to this line, and this line's pretty severe. So this is law as ideology, looking underneath the words for what is actually being done, um, who is actually being allowed to do what, and it's certainly a plausible interpretation that this is pernicious rhetoric to say the husband has no right, because you don't mean it. You mean the husband does have a right, but you're trying to pretend you're not saying that. Okay, that's one interpretation. Um, I want to offer a different way of thinking about it, and I'm not saying which one is right or wrong, but I think both views have to be taken into account. Your editors are realists, they're legal realists, they're interested in behavior and power, and they're not likely to think about it this way. But I've come to think of that it's more complicated than that. So my counter argument would be, um, my counter argument would be, it might matter, probably does matter, that they say the husband doesn't have a right to do this. Now, in this case, this doesn't help. The husband is not guilty. But in a future case, that language might make a big difference, right? So the point here, and it's a point that runs throughout this course, is that legal doctrine, these arguments and these conceptual moves and these justifications, they tend to channel your thought in some directions and not in others. They don't give you an answer or a determinative result, but you start moving in a direction. It's like a great game of Scrabble. You put a tile in the middle of the board and it's wide open, but as the game goes on, you find yourself confined in certain areas, and certain other areas are not pursued, right? So here, the future conversation begins with the idea that the husband doesn't have a right. It isn't a strong moral justification for violence. We're uncomfortable with it. But intervention, particularly judicial intervention with its adversarialism and polarization of parties, does more harm than good. Okay, but then that's the conversation in the future. Does it do more harm than good? Maybe it does more good than harm. But you're talking about costs and benefits. You're talking about consequences in the future. Your direction has been moved in that down that quadrant of the Scrabble board, and that for stopping violence, that you're probably better off with that conversation than the rigid hierarchical justification of domination and subordination as wonderful and correct and right and proper and a matter of right. So you want to pay attention to this tension, that what happens to this idea in the future about more harm than good. It's not explicitly taking up, it's just it taken up later, but in the cases, but it's just an observation in general about doctrine and how and why it can matter, um, in terms of framing what you can say and what you can't say. Okay, too long again. I'm sorry. I just, that's what I'm trained to do. Just babble on incoherently. See you next time.